The PMAC primarily handles European patents and unitary patents, but its scope is broader than that. So also covering related IP issues such as trademarks, designs, licensing agreements, and damages arising from patent infringement. Disputes can be referred to PMAC through three main channels. So it's courts, including UPC or national courts, administrative authorities such as patent offices, or direct submission by parties, so through contracts or mutual consent of the parties. And in the early years of the PMAC's operation, it's expected that most cases will originate from the UPC. The rules of procedure of the UPC already allow cases to be referred to PMAC at any stage of litigation. And moreover, UPC judges have an explicit duty to explore settlement possibilities, including mediation or arbitration through PMAC. To encourage referral, if PMAC is used to settle proceedings, resulting in a settlement or arbitral award, that will lead to a 65% reimbursement for the party liable for the UPC court fees. At the moment, 4 PMAC processes can be identified, of which the 3 are shown on the slide. The first category includes facilitative processes such as mediation. In mediation, a neutral third party helps the parties to communicate and negotiate with the aim of reaching a mutually acceptable settlement. In some cases, the mediator may also propose possible solutions if the parties request that. In the second category, that consists of advisory processes, such as early neutral evaluation. This process is widely used in jurisdictions as the United States, but it's less common in continental Europe. In early neutral evaluation, an experienced expert reviews the strengths and weaknesses of the parties' positions. This evaluator may provide an opinion on the likely outcome of a case, and such reviews can help the parties to decide whether to continue litigation, to settle, or to pursue another form of dispute resolution. As a third option, PMAC will also offer arbitration, which is a more formal dispute resolution process, in which a neutral arbitrator or arbitral tribunal issues a decision on the dispute. Importantly, PMAC will provide 2 types of arbitration. We have the binding arbitration, which results in a final decision that's enforceable and resolves the dispute definitely, and a non-binding arbitration, which provides a recommendation to encourage settlement discussions between the parties by providing them with an informed perspective on the dispute. And as a fourth option, PMAC will also allow parties to combine different dispute resolution methods. For example, parties might begin with mediation and move to arbitration if mediation fails. Or vice versa, arbitration may be also paused to allow mediation discussions to take place. These hybrid approaches offer additional flexibility. Another example is the so-called baseball arbitration. In this method, each party submits a final proposal and an arbitrator must choose between one of them. This method encourages submissions of reasonable offers by the parties and is particularly effective in disputes concerning royalty rates. PMAC sets clear time limits. Mediation is generally expected to be completed within 3 months, although extensions may be granted in exceptional circumstances. Standard arbitration should be resolved within 1 year, while expedited arbitration proceedings should be completed within 6 months. These limits are intended to provide parties with faster dispute resolution compared to traditional litigation. Flexibility is a key feature of PMAC proceedings. Parties control the process, including whether ADR runs parallel to litigation or pauses it. In mediation, parties are free to withdraw at any time if they believe the process is not productive. This voluntary nature ensures that ADR remains a cooperative and constructive process rather than a compulsory procedure. Also, the seat and language of arbitration can be chosen by the parties. Parties are free to choose the seat of arbitration anywhere in the world. The seat determines the procedural law and which national courts have supervisory authority over arbitration, including matters such as later challenges to arbitral decisions. It's important to note that the institutional seats of PMAC, which are in Lisbon and Ljubljana, are not automatically the seat of arbitration. They are administrative locations of the center. If the parties wish, hearings can be held at these locations or anywhere else in Europe. The language of proceedings is also determined by the parties. If they cannot agree, PMAC will make a decision for them. Then when to use which method? The choice between PMAC mediation, arbitration, or ordinary UPC proceedings ultimately depends on the desired type of solution. Mediation is best when parties wish to maintain a business relationship or mutually beneficial solutions are possible through negotiation. This can include licensing conflicts, friend discussions, or collaboration issues. And major benefits are confidentiality and quick party-driven outcomes. Arbitration is more appropriate when the parties want a binding decision, but do not necessarily wish to pursue a public court procedure. This can especially be useful when technical expertise, discretion, and international enforceability are important. It's a strong, flexible instrument for complex commercial disputes, while maintaining the option for confidentiality. UPC proceedings remain a natural forum when formal judicial rulings are required, such as injunctions, provisional measures, or enforcement. PMAC does not replace the UPC. It complements the UPC by offering effective, flexible, confidential, and quick methods. In conclusion, the Gowling versus Mertz and Viatris case from the introduction illustrates that the possibility of public access to the file of UPC proceedings and the practical challenges when parties want to protect confidentiality during litigation. PMAC offers a valuable alternative. Through mediation or arbitration, parties can resolve patent and commercial disputes efficiently, maintain confidentiality, and retain control over the process. As such, PMAC is set out to become a significant tool for IP dispute resolution, complementing the UPC while also aiming to serve as a global ADR institution. Thank you.